Do we have any alternates that need to be seated? Representative Broda.
I'm sorry, yes.
Senator Whitley will not be here, so.
Correct.
So you can sit in for Senator Whitley. Okay. The minutes of the previous meeting,
Madam Chair, I move approval of minutes of previous meeting.
Second.
second by Representative Schmidt. Any discussion, changes, or comments? All right, seeing none, those in favor?
Aye.
Those opposed? No, none opposed, okay. The consent agenda are there any rules to be removed from the consent agenda?
I did want to let you guys know that on page 2 of the consent agenda, letter O, 2022-149, that's actually a conditional approval. It just is in the wrong place, so.
Oh, so the Board of Psychologists is a conditional approval request?
Yes.
Okay. No. Okay. No, nobody's taking anything off. Okay, is there a second?
Second.
All right, any discussion? Those in favor?
Aye.
Opposed? All right, that's the consent agenda. And I'd like to thank the staff for making sure it was as long as possible. All right, regular agenda, Health and Human Services.
Okay, so I'm going to talk about these two proposals together, 2022-99 and 100. Both of these are radiation safety proposals. They deal with licensing and radiation safety requirements, and they were previously postponed from the November meeting after some discussion by the committee. There was only one issue that remained, and that was an issue with the fiscal impact statement. The rule amendments added requirements by inserting a citation within the rule, and that was to HEP 4038. But the agency's request for fiscal impact to the LBA didn't inform the LBA that the inclusion of those requirements would not result in a fiscal impact because the regulated entities were basically already adhering to similar requirements that were administratively attached to as a condition on their licensure by the federal government after 9/11. The agency could not get an amended FIS because there was no, they didn't meet the statutory requirements to do so. And so after some discussion, the committee decided to postpone. The agency requested to postpone to January so that it could have enough time to get together revised FISs for both of these, which isn't something really that's, in 541A. But they were able to get 2 revised FISs, and both of those are in the FP meeting packet at the end of the packet. Basically, the LBA states that the cost, if there are any, would be indeterminable from additional necessary security measures. But there could be some benefits from securing the radioactive materials from theft and from providing additional protection against unintended radiation exposures. But anyway, both of those 2 proposals have those the revised FIS associated with them, and I have no further comments associated with the proposals.
Thank you. Are there any questions or comments from the committee? Okay.
Do we need to hear from the agency at all?
Good morning. Sorry, I wasn't sure if you wanted me to introduce myself. Nicole Valenzola, Department of Health and Human Services, Rules Coordinator.
Okay. So do you have anything to add?
No, I'm here. I'm happy to answer any questions if you have any.
Okay.
Madam Chair, I move approval of 2299.
Second.
Any further discussion? Those in favor?
Aye.
Opposed? All right.
Madam Chair, I move approval of 22100.
Is there a second?
Second.
Okay, second by Representative Lynn. Any discussion? Those in favor?
Aye.
Opposed? All right, that's,
You probably got the easiest one of the day. Other than the consent calendar.
okay. The Board of Veterinary Medicine is still working on theirs. Do we have a motion to postpone?
Second.
Any discussion on this? This does not need a waiver because we're postponing it to the February meeting.
That's correct.
Okay, so discussion? Those in favor?
Aye.
Opposed? Okay. Thank you very much. That's postponed. Department of Justice. This is a new one.
Yes, thank you. These are the Justice 1600 procedures for pharmaceutical drug collection and disposal program. Currently, there are 5 substantive comments that remain on this particular proposal. The note to jail car on page 7, the agency did submit the rest of their incorporation by reference statements, so that no longer applies. But the first substantive comment appears on page 1. This is a definition where there is a requirement which is not in compliance with the manual, so therefore has to be reworded. The second substantive
Excuse me,
comment,
if it's rewording, isn't that an editorial comment?
the reason we had it as an unclear editorial comment is because this same comment was made on the initial proposal and the agency did not change it. So we did have concerns that there was a reason that it wasn't changed.
Oh, thank you.
The next substantive comment appears on page 2 and page 3 of the rule. The agency states that the law enforcement officer who is proposing to have a take-back event or a permanent box needs to get permission from the DEA, and they cite to a federal rule. However, that rule simply lays out when this may happen and gives the states the ability to do it. It does not state that the agency or the law enforcement officer needs the authorization of the DEA to do so. So there was an unclear comment on why authorization is required from the DEA, what particular statute or rule requires that, as staff could not find that particular statute or rule, and additionally what that authorization will entail, which ties into the unclear comment on page 5, the section for waiver requests. It's unclear because if the law enforcement officer can waive a request of the rule, it calls into question whether or not that will affect the authorization from the DEA.
Yes.
The final
Well,
comment.
now, I'd like to hear from the agency about this one because.
Thank you, Madam Chair. Matthew Broadhead here. I'm a Senior Assistant Attorney General. I'm here on behalf of the Attorney General. This is a readoption of rules that have been in existence for 10 years with minor changes from stakeholders in the law enforcement community. I'll just, if I could, take those comments just one at a time. The initial proposed rule as filed did not contain a comment with respect to the definition. I have the copy of the initial proposals here. So the addition of the edit unclear with respect to the definition of inner lining is actually raised at the first time in the final proposed text. And that, if I might just explain why it's worded that way, this was a comment actually from the then outgoing police chief in the town of Windham. He had mentioned that there are certain law enforcement officers that do the best that they can in these drug take-back collection events, but they don't necessarily collect them in inner linings consistent with the DEA requirements. So this definition is nearly verbatim with the DEA definition for drug take-back events. And so the reason why we just asked the committee to adopt it as written would be because we don't want to create differing standards between the DEA regulations and the state regulations. It would create unnecessary confusion.
Excuse me, so this is the first requirement that there be an inner lining?
This is a change in from the old rule to the current rule. The inner lining provides what law enforcement officers, when they take evidence into, of a crime, they have a sealed evidence bag that's logged, and you can track if it's ever been tampered with, who's had access to it, What this inner lining does is it creates an industry standard, just like pharmaceutical agencies, CVS or your standard drug take back locations. It brings them in line to that process so that they're not just placing during drug collection events unwanted opioids into a trash bag that's then stored on a shelf for a while. So it does create that level of, brings it in line to evidence until it's destroyed.
So this is a new requirement on local communities that are choosing to have take back.
It's a new requirement for those communities who opt into it. It's not a mandatory program, and the reason why the waivers exist is for those communities that are not able to comply for whatever reason. These bags are on retail for Amazon for about $10 for a dozen or so. But yes, it is a requirement for those single day take back events and for the standalone pharmaceutical collection boxes.
Thank you.
I'm sorry, one, and,
Questions?
I'm
Yes.
sorry, yes. And again, this is an opt-in program, so communities can choose to do it, so we're not forcing an undue mandate on them. That if they want to do that, they have to accept that this is part of the process.
That's correct,
Thank
and
you.
I've got statistics from the DEA actually that were that are from 2021, and there are, as the committee knows, there are over 300 communities, not in the state of New Hampshire, but not all have their own police departments, but total law enforcement in the state of New Hampshire is among the highest as percentage of law enforcement population. We have 125 communities that took place in drug take back days. There's 128 locations for those drug take back programs, and in 1 year, New Hampshire has collected over 10,000 pounds of opioid prescription drugs. And that was the 2021. Since the adoption of this rule and our participation in the program, New Hampshire has collected over 192,000 pounds of illegal or expired prescription drugs. So this has been heavily utilized in the community.
Okay.
With respect to the comment, so
Excuse me, we have another question.
go ahead.
Representative Schmidt.
Thank you, Madam Chair. You were discussing a moment ago that not all communities in New Hampshire have police departments, and I know that there are some that where the state police basically provides law enforcement. What if one of those communities wishes to take part in this program? Do they? How would they do that? Do they just ask the state police, and is there some kind of an issue if the state police are doing it because they have a kind of a much larger range of duty and authority as well? So could you speak to that?
Thank you, Representative. That's an excellent question. State police has primary jurisdiction in those communities that are under 3,500, I believe is the number. It might be 4,000. And in those communities where the select board wants to partake in a drug take back program, they are able to utilize the resources at state police, and state police would provide a trooper for those 1 day take back programs. It's always an option for those communities to reach out to the colonel or to the troop commander in their area where they'd be able to arrange for that to happen.
Thank you.
And
You're
if I could just respond to that very quickly.
Yes, Representative.
First off, I apologize about the comment with the IP. And then secondly, the reason that it's unclear is because if you are planning on keeping that requirement, it will need to be placed somewhere else in the rule. We're not saying that it has to be taken out. It just cannot be in a definition, as that goes against the manual. Looking at the rule, if you want to have the inner lining requirement for permanent and for take back programs, those could be moved down further in the rules, specifically to 1603.01 for the permanent boxes, just throwing that in as a requirement. And then additionally, for 1604.02, just once again, adding another paragraph to just have that requirement in there instead of in the definition.
Fine. So I think that would be a simple way to do it, is to simply move it to what is a more appropriate place to put that requirement. Is that agreeable?
I can look at that. The reason why I push back slightly, and I granted the rules are clear. I ask for an exception in this instance, just simply because the law enforcement community has a lot to shoulder. And when they look up the definition of interlining at the DEA under the federal regulations, they're going to see these requirements that are in the definition and that it needs to be capable of being sealed immediately. I think it's more efficient, frankly, to have the definition leave it the way it is, understanding that, you know, we're not trying to create unfair surprise by pigeonholing or shoehorning whatever the right idiom is into the definition. You know, we're not trying to pull anything on it, but by and large, the community in the law enforcement community understands what an interlining is and that it requires it to be sealed similar to an evidentiary bag.
Okay.
But yeah, I obviously defer to the committee on that. Just in terms of the comment on page 2 and then the subsequent comments throughout, initially, our initial proposed rule did not have the CFR reference. We provided the CFR reference in response to a comment on our initial proposed rule that said, you know, insert the CFR. So we did insert the CFR. It's actually, it could be improved by saying it's the chapter. It's 21 CFR chapter 1317. The reason is that you have to register the location of every collection take back program with the DEA. They need to certify that there is in fact a location that where these events are occurring or where the drop box is occurring. And that's not, it's not cited at any particular point in the CFR. So I could not provide a particular CFR where that is, but it hinges on the definition of registered location, and it hinges on a couple different areas where law enforcement has the authority to participate in these take-back locations.
Representative Schmidt?
Thank you, Madam Chair. So you referenced drop boxes. So would there be circumstances in which a drop box is provided and there's no individual, no law enforcement person there to monitor, or in other words, somebody could come and not only drop off, but also potentially take? Is that a possibility that the drop box would be unattended?
Yes, and they've accounted for that because the rules for drop boxes are much more strict. They need to be located on the premises of the actual police station or the law enforcement location. It needs to be under video surveillance. There are certain bolting mechanisms. The actual canister itself can't be tampered with or accessed. These have been for the communities that have the resources to support these drop boxes. They are very effective because people who may have an addiction problem don't necessarily feel safe enough to go and face a law enforcement officer face to face to admit that. And so having those locations where they could be dropped off anonymously is an important resource to the community.
Well, thank you for that clarification. That really helps to understand how it works. Thank you.
Okay. If I have a question, if do I understand you correctly say that there's no clear definition in the federal rules as to how they would reply to a request or notification from a police department?
No, the written authorization piece just is a review on the part of the DEA to make sure that the location requirements satisfy the DEA rules for either drop boxes or one-day take-back events.
So how do they get back to the New Hampshire police officer making this request?
How do they contact them?
Yeah, I mean, how it sounds, from what you say, it sounds as though the police request this approval or notify the DEA, and then they can't do anything till they receive authorization. How is that authorization provided?
That's a good question. I don't know the specifics, whether it's a phone call or whether it's a written correspondence back. I'm happy to find that answer out. I don't know the mechanism for how they give the feedback to the location.
Well, I hope
who's
it's not
requesting
a
it.
phone call because
me
our,
too.
our rule specifically says written authorization. So,
Yeah, I don't know. I'm
don't
sorry.
know how they do it, but, you think that that's an acceptable thing to have in our requirements?
I do, and here's kind of this is that provision has been in for the last 10 years. We had a, robust reach out. This is a joint rulemaking authority with the Department of Safety, the Department of Environmental Services, and the Pharmaceutical Board. We've reached out to all stakeholders on this. We reached out to the Chiefs of Police Association. Chief Becky provided feedback that this is a program that's working. It's well understood in the community, and that particular authorization requirement, when we had our public comment period, was not something that ever came up.
I'm glad to hear that. Any other questions before we go on to the next comment? Okay. Continue.
The last comment is an unclear comment on page 6 of the rules. This section lays out an alternative procedure for having a take-back program. This comment was also made when these rules came before the committee back in 2012. They were adopted with this particular part included. However, we make the comment again that if there is already a procedure to waive the rules, what is the need for an alternate procedure? And additionally, back to the comment with regard to the waiver, how would that affect the authorization from the DEA?
Thank you.
Please.
So I was able to pull the letter that was addressed from the then Administrative Rules Director who oversaw this process with the original jail car approval. And that section 1608 was originally titled exemptions, and the jail car comment was to change that heading to alternative procedures. There's 2 programs that are authorized by the DEA. One program with 2 alternatives, and that is what we've adopted here. It gives the maximum amount of flexibility to the local communities that can't maintain a permanent drop box, that it gives them the opportunity to have these one-day take-back collection events, which is what you see in 1608. It is by far and large the most preferred option by the local communities. And the rule, to the extent that there's, in terms of the statute, what it says is that it authorizes the Department of Justice and these, in conjunction with these other agencies, to adopt rules to clarify what programs would be available. And we've outlined 2 non-mutually exclusive programs. An agency can set up a Dropbox, and they can also have a take-back program. It gives maximum flexibility to the communities.
So the alternative is actually in the federal rules, and so we're complying with one section or the other.
Correct. The rule is 21 CFR 1317.35, and it authorizes specifically for law enforcement officers to engage in take-back events or collection receptacles located inside law enforcement's physical address.
Okay, so that seems clear to me. Any other questions, comments? Yes, Representative Leon.
Thank you, Madam Chair. It appears to me that there's also the one-time procedures in Rule 1604. Is that a different one? That has it's titled periodic or
Right.
one-time pharmaceutical drug take-back events.
Yep. So to the extent that there's the program that's been established, and say there's a shortage, a lot of law enforcement communities, this is a good example, are experiencing a shortage of officers. So to the extent that they still want to participate in a community take-back event and that they can't have two officers present for the actual take back event at all times, they can request a waiver at the DOJ to, waive that two-person requirement. What would be helpful is with this lining addition is that it would actually enable more communities to have one person, because it would double secure whatever drugs are taken back, to the extent that there's a tamper-proof inner lining with one officer, that that makes sure that there's no foul play that could be had.
So
Follow up.
sorry, follow up. Thank you. So it has the normal procedure with two officers in 1604, which then would need a waiver, which is 1607. And then is 1608 an entirely different alternative that doesn't require a waiver in order to fit into that one officer and tamper-proof liner?
I'm sorry, say that one more time.
So the standard community take back day is 1604. And you said they may need a waiver, which is 1607. And then we have the alternative procedure at 1608. Is 1608 just codifying one of those differences with the one officer and the tamper-proof lining?
I'm sorry, I don't think I understand your question. Can you say that one more time?
We have one-day takebacks in 1604,
Yes.
which can have a waiver through 1607. Then I don't know if that would
Oh,
handle your one officer or if that's just a separate
I'm-
codification of it.
I'm sorry. So to confuse you, yes. So the 1608 procedure are those entities that are providing that are solely governed by the DEA procedure and where there's preemption. So that's my fault. I'm sorry to cause confusion. So where there is an entity or a law enforcement officer that is specifically designated by the DEA to conduct at the request of the federal government through their own federal delegation, these rules are generally not applicable anyways. They'd be preempted. But what this provides is that if you're acting pursuant to a DEA authority, that you follow the federal mandates. I'm sorry for the confusion there. Thank you for that clarification.
Thank you.
That is not clear that because it looked to me like you've got, the standard, the one at a time procedure, and then there with waiver options, and then you have a totally separate thing.
Right, and I think that's why it was originally titled as an exemption and not alternative procedure. When the jail car originally was presented with this rule, there was
So
this
what's
whole
the
was a
difference?
completely exempt.
So 1608 is an alternative procedure for essentially non-law enforcement entities. Is
No,
that-
it's
you
for
would-
law enforcement entities that are designated by the DEA to act in accordance with federal law.
I think that should be indicated somewhere, that it is specific, there are only specific law enforcement agencies that can use this. Because this reads like, if my town decides to set one up, they could use this procedure. And apparently they can't, because I'm sure we're not on the list of specific authorizations.
Happy to clarify that.
Okay, thank you. I think the title would be the place to put it. Any other questions?
Madam Chair.
Yes, Representative Lyon, Senator Lyon.
It's fine. So two things. I am too also confused by the three different programs that are listed and who is responsible for which one and who's eligible to use which one. But I am not unclear on the inner lining conversation. I guess I just wanted to just go back to that first conversation point we had about inner linings, because if you look at the definition right above inner linings, it's a Dropbox, and Dropbox says it has to have an inner lining. And then the next one is just a definition of what an inner lining is, so they know what has to go in there, so they don't use a Shaw's bag, right? So I guess that's the best way I could say is I'm okay with the definitions as they are. It just cleans up exactly what's in the definition above that says a Dropbox has to have an inner bag, and an inner bag is, and it tells it what an inner bag is. So
Agreed.
Great. Okay. Hmm. So is there any other any other comments, discussions, questions?
No, I'm good.
No. In that case, I think I will move to approve conditionally that the heading for Justice 1608 specify that is only for previously approved law enforcement agencies or something for specific law enforcement agencies designated by the DEA.
Second.
Any further discussion? Okay, those in favor?
Aye.
Those opposed? Okay, thank you very much.
Thank you very much for your time.
Okay. All right,
Okay.
Board of Education.
Board of Education, so I'm looking at the conditional approval for 2022-138. On page 2, all the page numbers say 1, but there's only 3 pages, so, and so I'm looking at, ED 150105, paragraph C. So this is the only issue, and the paragraph reads, if the department finds the innovation plan performance is not improving at a sufficient rate. So these are innovation schools. They come up with a plan, and then the Board of Education evaluates their progress. But improving at a sufficient rate is, I mean, it lacks criteria. It's, it's not clear enough for a person to actually know what they need to do. The second half of what they added there, or that the plan is not achieving the planned results, isn't that's a criteria. So you would know what you need to do to make that happen, but improving at a sufficient rate just isn't clear enough. So
And I believe you're the department ready to explain this to us.
Hi, good morning. Julie Shea, Department of Education, Administrative Rules Coordinator.
Hi, I'm Elizabeth Brown. I'm counsel for the department.
We are happy to remove improving at a sufficient rate so that it simply says is not achieving the planned results. That is covered in the innovation plan, and that way there's no gray area of what a sufficient rate is. We don't want to define what a sufficient rate is because the local school boards are the ones that should be reviewing these plans, and we don't want to overstep that either.
that would work.
Okay. Thank you. That's
Move to
For-
approve as edited.
Second.
any discussion? All right, those in favor?
Aye.
Opposed? Okay, thank you very much.
Excellent, thank you.
Great, thank you.
Lizzie. Insurance.
So this is 2022-163 on procedures and adjusters. The agency did file a conditional approval request, which removed all but 2 comments. The first comment appears on page 2 of the rule. The agency uses may instead of shall. The agency had responded that this was part of the model rule language and therefore makes them exempt from having to use the shall. However, in a conversation with the agency's attorney just now, it seems there was a bit of a miscommunication. That language was actually pulled from guidance, not the actual model rules. So therefore, our comment would stand that this needs to be changed to shall.
Good morning. I'm Heather Silverstein, General Counsel at the New Hampshire Insurance Department. Yes, there was a disconnect at my agency as far as model rules and laws from the NEIC, the National Association of Insurance Commissioners, as opposed to guidelines. And I did have a discussion with Rebecca before this, and it would be fine to have shall instead of may. So we can change it that way.
Okay, thank you.
Madam Chair, move to approve as edited.
Any discussion, comments, questions?
And there was
yeah,
one
I
more.
Jumped too
believe-
fast. One
I
more
There was
edit.
one
believe
more
you have another-
comment.
I apologize. I withdraw my motion.
Never mind.
Trying to get
Okay.
this done.
So
I didn't see the second.
I thought that we allowed the insurance department to follow guidelines as well as model rules.
I believe the exemption only is for the model rules as opposed to
Okay,
the
well, that's
guidance.
funny.
And just to be completely accurate, this is a handbook that came out from the NEIC related to producer licensing. So when I looked further down and had the discussion with Rebecca, my concerns are alleviated. I'm fine with shall.
Okay, thank you. Please continue.
The second substantive comment, which is found on page 4 of the rule, I also had a conversation with Heather about this one as well. The comment was not to remove the citation for the statute, but rather to also include what the agency's procedures are in determining what penalty shall be given for whatever action. We understand it is factually based, but our suggestion was to just cite to the Insurance 200 rules, which is their adjudicative process, to which it sounds as though the agency is in agreement with that.
Yeah, so having the conversation with Rebecca this morning, I would be fine. I thought she wanted us to remove the penalty statute altogether, which we do not want to do. Because we always defer to that in our rules. It's consistent. And if that statute ever changed, we just change as the statute changes, the rule changes. So I would be amenable to adding an INS 200 as that applies. And the reason I would like that qualification is because it applies when there's a hearing. And so there could be a scenario where there's no hearing. And as an example of that, let's say the producer doesn't renew because the license is not renewed because they don't meet the educational requirements, but then they don't sell. And then they go get their educational requirements, and then they submit that, which is what this rule is saying. Once you submit that and you're in compliance, then you're fine. The other scenario is a producer doesn't renew, doesn't meet the educational requirements, and keeps on selling, even though their license isn't renewed. That would trigger us to look further into it, and then that would end up at an administrative hearing. And so that's why I would rather have an INS 200 as that applies.
Thank you. I think that's clear. Any other comments?
No further comments.
Senator Lang.
We'll try this again. Move to approve with the edits as presented.
Any further discussion, comments? Seeing none. Those in favor?
Aye.
Opposed? All right, thank you very much.
Thank you.
Okay, OPLC Natural Scientists.
So the only issue with this rule is that some of it expired in March of 2019, and some of those rules included disciplinary sanctions and administrative fees and some other things. So you may have some questions about that.
Why, yes. Good morning.
Good morning, Madam Chair, members of the committee. For the record, Lindsay Courtney, Executive Director, Office of Professional Licensure and Certification. So I think the committee is well aware of some of the challenges that OPLC has faced in our task and plan to establish internal controls within the agency. We recently, in addition to coming up with a plan to ensure that rules are not expiring, which this is the result of that inventory that we conducted. We also inventoried all of the existing fees in preparation for filing that you should be seeing shortly to memorialize all existing fees in one filing, and discovered that the fees had been expired. So that finding was made in November. So we're presently working on the refunds that we are used to doing. Unfortunately, in the past with fees expiring and the lack of internal controls in the agency. I do think that with the filing that we intend to make, and I know we're working on the fiscal impact statement right now in the 1002s, that should remedy the situation and prevent it from happening in the future. Happy to take any additional questions.
Senator?
So just to be clear, the rules expired. We have collected fees. We're returning the fees because we didn't have rules and we're ready to move forward.
Correct.
Thank you. Move to approve.
Any further is there a second? Second. Okay, thank you. Are there any further comments, questions, discussion? Seeing none. Those in favor?
Aye.
Opposed? All right, thank you very much. And court reporters.
Okay, so 2022-9 for court reporters is an interim rule, which if adopted, it will be effective for 180 days. This is one of the boards which was changed to an advisory board to the executive director of the OPLC during the last legislative session. There are currently effective rules which most likely are unenforceable because the authority has been transferred. So if adopted, there will be 2 sets of rules effective. However, the OPLC does plan to repeal the currently effective rules after adoption of these rules. Besides that issue, there are 2 major issues to bring to your attention, and there are a couple of minor ones as well, despite the filing of a conditional approval request. But those minor issues can be handled during regular rulemaking. So for sake of time, I'll just discuss the 2 major issues. The first one is on page 9 of the FP package, or page 3 of the rule. There is an issue of statutory conflict and authority that needs to be addressed by the legislature, and that's at PLC 1203.04A. There, you're going to see that the rule is talking about the records of the former board, that they shall be retained by the executive director in accordance with the retention scheduled established by the executive director. This language is what's in the statute, but there are 2 problems with it. The authority for retention of state agency records actually resides with the Secretary of State, the Department of State, which doesn't have any rules on the topic. So the statute is granting the authority to the executive director, and that conflicts with other statutes. The second issue is that just merely...
Okay, excuse me.
Yes.
So if I understand you correctly, that the problem is not with the rule, but the statutes.
Partly. The second part of this particular section is that they're just merely reciting what the statute says. So it doesn't provide any transparency for how or how long or in what manner the records will be maintained. This issue was in another proposal, I think, recently before the committee, and it was approved, but we felt like we need to bring this to your attention because of the statutory conflicts that need to be resolved. So that's the first major issue.
Well,
I can pause
I
there.
would like to say on that we can address the issue of lack of clarity in regular rulemaking, and the statutory conflict is somewhat beyond
Yes.
agency's control.
If I may also address that, Madam Chair, I don't view it as a statutory conflict. The intent of the statute, which authorizes the executive director to establish a retention policy, was to make clear that the agency, not the boards, could establish the retention policy in accordance with the RSA, setting forth the requirement that the Secretary of State approve the retention policy, because previously all of the boards had their own retention policies, and it's very difficult for an agency to execute 50 plus sets of retention policies for the same types of documents. We did work with the Secretary of State's office. I would agree that it would be nice if the procedures were a little bit more transparent. It took me about a year to get that retention policy approved, but we do have an approved retention policy pursuant to the Secretary of State's authority. So I don't view it as a conflict.
Okay. They could, and they could put some kind of detail here, around that retention policy. But again, Madam Chair, that could be done during regular rulemaking, whether that's 5 years or however it is that they're retaining that. They could just kind of flesh that out a little bit more in the rule.
Or they could simply provide a reference to the
Exactly.
OPLC retention policy, which is somewhere available. I'm
Yes,
sure.
we can
Right.
certainly do that in regular rulemaking.
Okay.
Madam Chair.
Rapidly.
In this instance,
Correct.
most agencies will specify a period of years, such as 4 years, and then will also say, unless otherwise established pursuant to the rules that are supposed to be adopted by state. I do plan to talk with the Secretary of State about adoption of those rules.
Okay. Thank you.
Okay, the second major issue is on page 18 of the final proposal package, or page 12 of the rule. You can also look at page 3 of the conditional approval request. Here at PLC 1205.06 on documentation requirements for audits, the rule says that failure to submit documents when told to do so represents a rule violation for which the executive director can take disciplinary action as provided in the rules and as provided in a cited statute. The problem is that using the phrase "can be taken" violates the rules, which actually says later on that the executive director shall impose discipline. Even if you ignore that, the citation to PLC 1208 doesn't really work, because that section only describes the aggravating and mitigating factors for when determining what discipline shall apply. It doesn't outline what the executive director will consider whenever initiating the discipline. Additionally, the citation to the RSA 310A174 doesn't really work either, because there's not a catch-all category in the statute that would directly apply. It describes actions that would be sufficient for incurring discipline. Missing paperwork doesn't really fall underneath those categories. It could possibly fall underneath willful or repeated violations of the statute. That's a little bit of a stretch. So those are the two issues with this proposal.
I don't take issue with changing can to shall. I think that the result obviously would be to eliminate discretion in determining whether or not to discipline an individual, but I support having objective criteria, and I would be happy to change it to shall.
And the references to the PLC 1208 and so forth can be fixed in regular rulemaking.
Yes, ma'am.
Okay, thank you. Any other concerns? No?
No, ma'am.
Questions? Comments?
Given the editorial comments, I move to approve the interim rule.
Again,
Okay. Any further discussion? All right, seeing none, those in favor?
Aye.
Opposed? Okay, thank you very much. Medical imaging.
Yes, thank you, Madam Chair. So this rule also was put in, is also an interim rule because the board has been turned into an advisory board under the OPLC. The only two comments I had after the OPLC submitted conditional approval are two that were just discussed on the previous interim rule. The issue with other rules currently being in effect under the old board. It sounds like the OPLC is going to repeal those after these rules are put into effect. And the other was for the retention policy, which we just had a discussion about.
Okay. I thought that when we converted those boards to advisory, we put a general statement that existing rules are valid until expired or replaced. We did not?
not in all instances. That has occurred. I plan to talk with the Director Aliakonis and some of the bill drafters about making a little more uniform language because we've had several instances, especially with the boards that are becoming advisory boards, and even back to when PUC was split into PUC and Energy, that there has not always been a clear definition of what rules carried over, etc.
Well, I tried to put that in my OPLC reorganization bill. That was the only comment that I specifically added to it, is that the rules apply until repealed or expired.
I take responsibility for that one. I should have noticed that when these were going through.
Okay, well, I think we would have the same editorial comments on this rule as the previous one, and same intent to clarify during regular rulemaking. So is there a motion?
Move to approve the interim rule. Excuse me.
When he recovers.
Move to approve the interim rule.
Second. Go ahead. No.
Any further comments, questions? All right. Seeing none, those in favor?
Aye.
Those opposed? All right.
Madam
Excellent.
Chairman,
Yes.
I'm not certain whether it was Representative Schmidt or Representative Lynn that seconded.
favor of Representative.
Alphabetical order, you know. All right, so that completes our business. I think we will not have a continued meeting this month. And is there any other business? In
Move to
that case,
adjourn.
Without objection, we will adjourn.
There we go.
Oh,
Madam Chair, I did send out an email to all the members and alternates yesterday indicating that because of the weather, we would not have a orientation meeting today. I did send out an orientation packet that should cover most everything, but we would be happy to meet with individual members or a group of the members to go over that.
Okay.
I know at least one of the members who's watching us on Zoom or whatever streaming method is. So maybe some of the other ones are as well, because I was delighted to find out that the roads from Dover to Concord were very drivable. When I looked out my window this morning, I thought, hey, 5 inches of snow and who knows, but the roads were great, so.
Okay. Thank you all for coming, and
Do we
thank
have a
you for
continued
efficiency.
meetings?
We do not have a continued meeting. We will meet in February on, what day?
Right.
17th?
We just thought that should be in the record that, yeah.
February 20th. Okay, we will see you all then.
I do.